Thank you. We are back live on YouTube. Before we took our break and watched the video, I believe that the people, and before we had the discussion at the bench, the people had risen to, I think, ask some questions of Detective Salahan. Is that where we were?
I believe so, Judge.
Okay.
The only additional question I have based on the video, Detective Salahan, towards the end of the video, for lack of a better term, what is taking so long at the point in time after Mr. Bailey says he wants to talk to an attorney? What's going on behind the scenes? Why is it taking so long?
To get him to where he needs to go.
Yes.
I contacted our patrol officers who were going to transport Bailey to the Huron Township Jail. And I reached out to them, and that was the time it took them to get to the department.
Okay, and just to be clear, do you house people at Sumter Township?
No, we do not.
Okay. And would it be yours or Detective Toll's responsibility to transport an individual?
Neither.
Nothing else?
So I have no more questions of him.
I'm sorry?
I have no more questions of this officer.
Thank you. Detective, thank you so very much. You previously indicated that that would be your last witness. Does that remain true?
It does, Judge. The only additional things I have are 2 lab reports that were received in this case. I have pre-marked them for identification as people's proposed exhibits 6 and 7. They are admissible under MCL 766.11B. The first is essentially a crime scene report. It's record number 1 and laboratory number MD 20-1788. The report is prepared by Tyler, spelled Tyler, last name Wrubel, a forensic scientist with Michigan State Police. It is signed and dated November 19th, 2020. I would move to admit that into evidence as People's Exhibit 6.
I have exemption for exam purposes only.
Shall be admitted for exam purposes only.
And lastly, as it relates to previously mentioned People's Proposed Exhibit number 7, this is lab record number 6 in laboratory number MD 20-1788. This report was prepared by Lisa Mayfield, forensic scientist with the Michigan State Police. And it discusses the processing of the truck that was recovered in this matter, this white Chevy Silverado. So I would move at this time to admit that into evidence as People's Exhibit 7.
No objection for exam purposes only.
Admitted for exam purposes.
And let me just double check. And so just to make sure, I have that exhibits numbers 1 through 4, the medical examiner's reports were admitted. Exhibit 5 is the 911 call on a disc that was admitted. Exhibit 6 and 7 are lab records 1 and 6 respectively that were admitted. Exhibit 8 is the Ring doorbell footage that was admitted. Exhibits 9 through 13, scene photos were admitted. And then Exhibit 14, defendant's interrogation that were admitted. And so with that, the people have no further witnesses.
Thank you. Ms. Woodside, do you have any witnesses?
Oh, no, Your Honor.
Argument from the people.
Yes, Judge, and before I do, can I pass up People's Exhibit 6 and 7 to the
Thank you.
court? Judge, this court well knows the standard at preliminary exam in order to bind over on the charges the people have brought against the defendant is whether or not we've shown to a probable cause standard that the defendant committed the crimes that he's charged with. In this case, the defendant is charged with 4 counts of murder in the first degree premeditated. In order to prove that to a probable cause standard, the people have to show that the defendant caused the death of Sarah Grupa, Grupa, Laura Tanner, Neil Sampson, and Forrest Sampson. That is, they died as a result of gunshot wounds. That he intended to kill those individuals, that the intent to kill was premeditated, and that it was deliberate. He's also charged with 4 counts of felony firearm, and essentially people have to show that he had a gun at the time he committed those murders. In this case, I believe that there is ample evidence, certainly to a probable cause standard, that the defendant did kill all of those individuals, that killing was intended and premeditated and deliberate. In this case, we have the medical examiner's reports that establishes that each of those individuals died due to gunshot wounds, and that the manner of death is a homicide. The court can infer, based on the number of gunshot wounds and the location of those gunshot wounds, what the defendant's intent was. Most of the victims had gunshot wounds to their head, and many had multiple gunshot wounds. Forrest Sampson, I believe, only had 1 gunshot wound, and that was to his head. And so that provides evidence reflected in the medical examiner's report alone of the defendant's intent to kill. And secondarily, the number of victims itself, it goes to, I believe, premeditation and that it was deliberate. So we also have on this record evidence that the defendant was not living at that location, that he had a history of domestic violence with Laura Tanner, and that they were having all of these property disputes over the house that was in her name, and the truck that he was driving that was in her name. The defendant, again, was not living there, but on August 15th, 2020, drove his truck. The court can see and infer that it's his truck on the Ring doorbell footage. And the timestamps on those videos that the court has received are approximately 2 minutes apart. He drives there. I believe the evidence shows that he immediately shoots Sarah Grupa on the back porch at the deck. And the court can review again the medical examiner's reports for the amount of gunshot wounds that she had on her body and the
I'm
location.
gonna object because I think that's not in evidence. Who was shot when? So the prosecutors arguing to the court, this person is immediately shot. There's nothing before the court that says that.
I can make an argument.
Overruled.
And then he proceeds, the officers testified that there were an extended magazine outside on the deck, and Sergeant Eager testified that there were shell casings on the deck. Inside the house, Laura Tanner is found. Forrest Sampson and Neil Sampson are also discovered. The question is, what evidence do we have that this was premeditated or deliberate? And deliberate. So again, the defendant is not living at that location. He had to come from a separate place to get there. That was testified to by Brianna Allen. He was living with her at the time. Notably and importantly, Ms. Allen testified that the night before, on August 14th, 2020, the defendant texted her and she asked how he was doing. The response was something to the effect of, she testified to, and the court will have to refer to her words, but I'll paraphrase, that he was feeling like clearing the scumbags out of his house vigilante style. That's absolutely evidence of premeditation. And that's exactly, in fact, what the defendant does the next day. He takes his weapons. I think there's ample testimony that connects the defendant to the .380 caliber gun that ended up being recovered in the truck. That's reflected in record number 6 that was admitted as People's Exhibit 7. In the .45 that he subsequently admits to in his interrogation, which we'll get to in a moment. And he basically execution style kills all of these individuals. What other evidence of premeditation do we have and deliberation? So in addition to the time he took, the time he had to reflect on his thoughts and his decisions to get to the house, every shot, every person that he murdered that day provided that time to reflect on his choices, and he continued to choose to shoot at these people. And importantly, there was no testimony that any guns were found at the house at 2/4 914 Martinsville Road. The only person with the weapons, based on the evidence admitted at exam, was the defendant. We also have evidence of flight, literal flight, and then speaking to his friends about what he was going to do afterward. Yes, he ultimately turned himself in, but he didn't remain at the crime scene. He left. Going back to evidence of premeditation, Ms. Allen testified that he left money for her in the top drawer, which shows that he knew what he was going to do. And again, the court can determine premeditation from the circumstances of the killing itself and what happened before and after the killing. Additionally, we have evidence, albeit circumstantial at this point, that the defendant got rid of his CPL card and, again, circumstantially, his phone that was found with the CPL card and discovered some months later and then provided to Sumter Police Department. So he's trying to conceal potentially evidence of his crimes. Again, we have the prior report of domestic violence. The facts of that report and what was testified to, because he had allegedly harmed Ms. Tanner in the past, this court, pursuant to case law, can use that to show propensity to commit these acts. And I think that his admissions to Mr. Sosha and Ms. Allen in and of themselves establish what he was doing. He also had told Ms. Allen that he just wanted to be done with Ms. Tanner and wanted to be something to the effect of wanted to be rid of her. Mr. Sosha testified about the defendant's statements to him. And Mr. Sosha's recollection of their conversation between 10 and 11 in the morning, just shortly before the killings on August 15th, that the defendant was mostly calm. That's what Mr. Sosha's testimony was. He was a little upset and irritated, but wasn't as bad as he was other times. And I think that that's telling. The defendant went over to the house with a clear mind and knew exactly what he was going to do. He planned it. And the court can certainly infer all of those things based on the evidence that we have in front of us. Again, premeditation and deliberation may be inferred from all of the circumstances surrounding the killing. And because of the difficulty in proving an actor's state of mind, only minimal circumstantial evidence is sufficient. And I think that the record speaks clearly to all of that. And this, I think that people have certainly shown each of these elements to a probable cause standard to support a bind over as charged. So I'd ask that's what the court do.
Your Honor, reading with the prosecution's last argument, I think the exact opposite could also be reasonably inferred by the court as it relates to this prior domestic violence. If they want to use that to show premeditation, the officer wasn't able to tell the court that there was any injury to this particular person. Mr. Sosha himself knew that they had a turbulent relationship. His recollection of the statements my client was making, he says that he was calm. Okay, well then, how is that being, how does that go to premeditation if they want to rely on his conversation with Mr. Sosha? That he wasn't angry when he had this conversation with him. He was calm. He was had been speaking to friends. As it relates to their argument about premeditation, based on what Ms. Allen has to say in these various text messages, when Ms. Allen was asked also on cross-examination, and you heard him make statements like this before, and she indicates that she had. It wasn't anything different than she heard him say over the previous year of their relationship, where she knew of his relationship with Ms. Tanner. Flight doesn't necessarily go to premeditation. There were no guns found at the house. It's equally true. There's a magazine on the deck. That doesn't go to premeditation. A number of victims, the history of domestic violence has already been discussed. The fact, I think it was Mr. Sosha who testified about they having discussed taking the truck to the property since everything was supposedly in his name. And though the officer in charge was fully aware, as was Mr. Sosha, as was Ms. Allen, that these items were actually Mr. Bailey's, but they were in Ms. Tanner's name because she had better credit. As it relates to him getting rid of CPL and that would have his name on it, I would imagine, and a cell phone that the officer, there's no testimony before the court that was his phone, was a phone that was broken. Those don't give the court enough evidence to support premeditation. There has to be a specific intent to kill. The fact that there was a killing does not of itself show premeditation. And that's the court not to bind over on first degree, because I don't believe the people have sufficiently shown the element of premeditation.
Ms. Hempline?
Yes, just to respond briefly, I think there's ample evidence of premeditation. All that's required for premeditation is time to think about beforehand what one is doing. There's no specific time required by law, and it just has to be sufficient for a reasonable person to subject the nature of his response to a second look. And that's Tilley, 405, Mish, 38 at 45 in 1979, Michigan Supreme Court case, as well as Anderson, 209, Michigan Appeals Court, 527 at 537 in 1995 case. And premeditation and deliberation may be inferred from all of the circumstances surrounding the killing. In this case, my argument was that Mr. Socha testified that Mr. Bailey was calm but upset. And I think that goes to show that he had a clear head and knew what he was doing and knew what he was about to do. He had to drive from a different location to get to that point. That's ample time to think about what one is doing and to take a second look at it. It's ample time to walk up from that location with your guns before you start shooting at somebody who's unarmed. It's ample time when you go into the house and start shooting at the next person and kill the next person. There's ample time to take a second look at your decisions and think about what you're doing before you go and start shooting multiple rounds at the next person. And then even down the hallway to the fourth victim. All of that time is time for him to take a second look at his actions. But we knew what he was going to do ahead of time because Miss Allen told us that the night before the defendant had already planned on doing that he was going to go clear the scumbags from his house vigilante style. And that's exactly what he did. That's hours and hours before he actually commits the killing. And so I think that based on the totality of the evidence that the court has heard today, there is ample evidence of premeditation and deliberation in this case.
The court has listened to the 6 witnesses presented today, reviewed the exhibits that were received, and the court will find that the plaintiff has met his burden, the people have met their burden in showing that both a crime was committed and that probable cause exists to believe that the defendant was involved in the commission of that crime having occurred in Sumter Township, Wayne County, Michigan. Defendant will be bound over on all 8 counts. The next appearance date will be May 3rd, 2021 at 9 a.m. at the Frank Murphy Hall of Justice. Previous bond, no bond, it was a remand. That will continue as well. Anything further on behalf of the people?
No, thank you.
Anything further, Ms. Woodside?
No, Your Honor.
Thank you. We are off the record.